Hello, everyone. Sufit here. We are here today with Charles B. Ticker, the state mediator and the state litigator. Charles, you're here today to tell us about a new practice direction to do with the court, to do with mediation, and a bunch of other stuff. Take it away, Charles.
Yes, so the Chief Justice announced that there's a new practice direction for the courts coming into effect on April 19th. And it's just talking about procedures and how courts are going to work going forward. As you know, we've basically been working virtually for the last couple of years, and things are starting to open up, and the courts then have to address what they're going to be doing going forward. So it depends on what you're doing, but for things like trials and those sort of things, those after April 19th, the presumptive method will be in-person hearings. So the court is opening up for trials and that sort of thing. But for a lot of the work, everyone has realized that there's been a lot of efficiency doing things virtually by way of video conference. And so for things like chambers appointments or scheduling appointments in estate matters in Toronto, motions, applications, the presumptive method will be virtual unless the court orders otherwise. And so we'll all be doing this by video conference. The only difference is if it's a motion or application where you normally would be in a courtroom, we're going to have to put on our robes and dress up for the camera, so to speak.
So you're going to have to stand in your own living room or den in your litigation room?
Well, I got to review the practice direction because I was thinking about this, and I'm not sure if we have to stand or we can remain seated. Obviously, in court, when you're in court, you got to stand up. If we don't have to stand up, then maybe people will still be in their PJs bottoms and just show from the neck up. I don't know. I imagine there's going to be some humorous episodes, and like that lawyer with the cat face. We're going to see people doing some embarrassing things because they're not used to going live, so to speak, on camera. But I recall even in the days when we were in court, I recall some judges who, when they would get up for a recess and walk out of the courtroom, you could see that they're wearing sneakers and blue jeans under their robes, so they were wearing the full formal attire. And there's I remember the late Justice Archie Campbell. I mean, I don't think I'm speaking out of school here, telling tales out of school here. He used to wear construction boots under his robes because that's what he wore. So
boots under the robes. Very interesting.
Yeah,
robes.
Under his robes, but instead of wearing dress shoes, he wore boots, construction boots. And because that's who he was, and he was a great judge, and we miss him. But anyway, so that's the change there for, and then for mediations, for discoveries, also in person, but for mediations also. We've been doing mediations virtually since this pandemic started, and the courts are saying now where there's mandatory mediations, the presumptive method is going to be in-person mediations, unless the court orders otherwise, or I guess unless the parties and their lawyers agree to do them virtually. And
so as a mediator, Charles, how do you feel about that? Should the presumption really be in-person mediations? Or, I mean, you're saying that's what it is now. Are parties going to want to go back in person, or do you think that it's kind of entrenched now that people are going to want to continue to do mediation virtually?
Well, there's been some debate about this already amongst the bar and mediators. I've been following some postings online where there seems to be some pushback here saying, did you consult the mediators about this? Because virtual mediations have been working very well. That's been my experience. And I think that's been the feedback I've been getting from participants and their counsel. I mean, I have mediations booked beyond April 19th now. And my phone was not ringing off the hook with lawyers saying, hey, can we go in live now in person as opposed to virtual? I haven't received one request for that. And I think there are reasons why keeping mediations virtual, makes sense. If and I can list a few.
Yeah. Tell it. Why do you think it makes sense to keep it virtual?
Well, it's just at a mediation, you want the parties to be comfortable and at ease, particularly in sibling disputes that I focus on. So when we were doing these things in person, there was this whole dance going on, like the siblings don't want to see each other in the room. We would do, let's say, a joint plenary session. They don't want to go into the room. They don't want to get on the same elevator. They don't want to go to the washroom with the whole thing. Like, I just want to avoid my sibling. So it is easier to avoid that sibling if you're a virtual on a video conference, because you can just turn off your camera so they can't see you. And we've actually done that in some cases. And why is that important? Well, the whole thing about mediations, you want everybody to be at ease and comfortable. And this meeting of siblings in person creates a lot of tension. And so that's one advantage. The other thing is just the commuting. Can you imagine you got to drive an hour downtown or be on the transit and finding places to park and rushing here and there? By the time you get to the court reporter's office or the lawyer's office where the mediation is, you're already tense. And it's just so much more comfortable just to grab your coffee and, put on your bathrobe. I'm not saying you should go in your bathrobe, but what I'm saying, it's so much easier just to be in your own home, the comfort of your own home, and just go online.
It's funny that you mentioned it, that 2 years has unseated 100 years of tradition. All of a sudden we think driving downtown and parking is such a big deal when we always had to do it. But you're absolutely right about that. So I have a question for you. Have you ever, as mediator or perhaps as counsel, attended a mediation where it was kind of a hybrid, where some people were there virtually and some people were there in person? Did that ever happen?
Well, yeah, I had one recently where that happened, where I was actually counsel, and my client and we attended virtually, and the other side insisted on being in person, so they attended in person at the mediator's office, and it worked. So we settled. So that's another possibility. But one of the arguments people make for in person, and maybe this is what the Chief Justice and the courts were driving at when they made this the presumptive rule going forward for in person, is that somehow the dynamic for settlement is going to be better if the parties are there in person. I personally don't buy that, because even when we were doing in-person mediations, people are sitting in their own room. They're not interacting with the other side at all. Everyone's in their own room, locked away with their lawyer, and the mediators, going back and forth between the rooms. The only negative thing I could say about video conferencing, is that it can be tiring and a bit of a strain watching a screen. So, but you encourage people to take breaks. And the other thing that I think people miss is, the great spreads for lunch and breakfast and snacks that these court reporters would put out. And so I miss that, but I still think on balance, virtual mediations work. And I think if you were to ask around, I think the consensus would be that people still see a great role to be played by video conferencing mediations. So it'll be interesting to see how this develops. For trials, if the court says you got to come to the courthouse in person, well, and there may be exceptions made for people who can't, or for whatever reason. That's one thing, you know, there's the judge and you got to show up. But if you're doing a mediation, and if everybody agrees that they're going to do it on Zoom, or I don't think there's anything that's going to prevent that going forward, but it would have to be with the consent of everybody.
So you're talking about, is there a difference between court mandated mediation and privately initiated mediation in this regard?
Yeah, there's nothing is that I take from the practice direction. I think that if you don't have to involve the court directly, there's no reason why parties can't consent to the method of the mode of the mediation on their own, whether it's mandatory or voluntary.
I wonder if there'll be data at some point that compares outcomes, if there's going to be more or less settlement happening as a result of virtual versus in person. I mean, I guess there's not enough data yet, but I wonder if at some point, what would be your guess, you know, about that? Do you think more cases settle in person or virtually, or does it not make any difference?
You know, I can only give anecdotal evidence. I'm not aware of any studies or that have been done. I imagine we maybe will see some, but my gut feel is that there's not a significant difference.
Yeah.
In the rate or the you know the number of settlements. I think it always depends on, are the parties ready to settle, and are they serious about making compromise? And I think you can achieve that in mediation, both virtually and in person. But I think the marketplace will dictate what happens. So if more mediations are being done in person, and that's what people seem to want, then that's where we'll head. But right now, I haven't seen a big, like I said, I have not seen a big pushback to change mediations that are already scheduled, you know, beyond April 19th. People seem to be happy to keep them as virtual mediations.
Especially helpful if they're from different geographical locations.
No question. If you're dealing with people with different time zones or different cities or provinces or states, it makes sense to do it virtually, of course.
Yeah. All right. Well, our guest today has been Charles B. Ticker, a state mediator and litigator. Charles, thank you very much.
My pleasure. Thanks.